Good evening and welcome to this meeting of the Employment Committee. I believe we're quorate, aren't we? We've got Councillor Perrott online. Good evening to you. You okay? Good. Have we got any apologies, please?
Thank you, Chair.
Rachel.
So Councillor Lisa Finan-Cook has sent her apologies and Councillor Hode is her substitute, and as you said, Councillor Tong Perrott is joining online.
Fine, okay. Minutes of the previous meeting, is everybody happy for me to sign them off? Good, thank you. Right, so any declarations of interest? No, fine, good, thank you. That leads us to the disciplinary policy and procedure, item 4. And I believe, Sally, you're going to introduce that?
Yes, indeed. Thank you so much, Chair.
Okay.
This is a suite of 2 policies, both relating to the corporate management team, one for grievance and one for disciplinary. It might be helpful for the committee to look at them together because we are trying to make them consistent with each other. The committee may be aware that statutory officers have to have a separate grievance and disciplinary procedure from other officers, and the reason for that is because there's councillor involvement in their disciplinary and grievances, whereas for other officers there are not. Surrey Heath made the decision some time ago to broaden that out to all corporate management team members, and originally we had separate policies for corporate management team members for disciplinary and grievance. We realised that they duplicated the main policy considerably, and so what we have tried to do is make a streamlined version that can be an annex to the main policy to avoid all the duplication we had and to make them easier to follow. We're very fortunate that the Chair and the Vice Chair have made some really great feedback for us, some of which we've completely accepted, but other bits the committee might want to debate. So what I thought I'd do with both the policies is just go through the feedback we've received from councillors and then allow you to debate the bits that are slightly more contentious, if that is acceptable to the Chair and the committee.
Yes, shall we, since the two are interrelated, as it were, shall we just, have you got any comments you want to make about the next one, the disciplinary procedure? Sorry, not on the wrong page.
I think it's grievance first.
Yes, it's grievance first and then disciplinary.
Happy to go through first grievance, then disciplinary.
Okay, fine.
So on the grievance policy, Sorry. So on the grievance policy, Chair, you pointed out that there was a little bit that looked as though it had been copied and pasted by mistake from the disciplinary policy, and you were absolutely right, we have now removed that sentence. In addition, there was feedback, I think, from Councillor MacDonald. One bit that was, again, a bit of duplication. So in the appeals section, there was repetition, so the same sentence had been repeated twice, so we can remove that bit of duplication. There was some feedback that actually was made in the disciplinary policy, but did also relate to the grievance policy. I can go through that now, or in the disciplinary, whichever you prefer. But I think the piece of feedback from Councillor MacDonald that was probably worth discussion is there was a proposal to add a sentence in the section about complaints against councillors should be referred to the monitoring officer in the first instance, that paragraph. there was a suggestion to add the sentence in this situation, so in other words, in the situation where a complaint against councillor has been received, both the employment rights of the CMT member and the privileges of the councillors will need to be respected. And I wasn't entirely clear about exactly what that meant, and I thought it was possibly worth a debate with the committee just to better understand that bit of feedback.
Okay. Councillor MacDonald, do you just want to sort of clarify that for us, please?
Yeah. Thank you, Chair. Could I just reorientate myself, because there's the two policies. That one is on the second one, isn't it? Is that right? That comment you just made was on the first one. Just so we're talking about the right thing, because flicking between screens here.
It's on page 23. It's the lowest paragraph on the page, starting with
Which policy? Sorry. Grievancy. So that is the second one. So I'm just wondering, in terms of process, is it possible to do are we doing the second one first and then coming back to the first one? Or can we just deal with the first one?
Yes, we can do
So,
the first one.
in the interest of effectiveness, if the chair would allow me, I think there are a number of things which I fed back to the team, and they were kind enough to process on time and think about. All of those things, I think, a number of those things, the team I think has accepted as being non-material changes, and the ones that they aren't happy about, I don't believe require further debate. So if the committee was minded to accept that I've given some constructive, should we call it, administrative feedback, and allow the officers to process that, because they've accepted it, then we probably don't need to debate the first one.
Okay, and that's on the first.
Yeah, on the first one,
fine.
just in the interest of time.
Okay.
Because I don't think there's anything there, having looked through the first one, I don't think there's anything there that,
Right.
to use a colloquial phrase, I'm going to die in a ditch for. I've just tried to...
Okay, so I'm quite happy with that. Members of the committee, does anybody else want to raise it? And we're talking about the first document now. Does anybody want to raise any other points about that? I'll take that as no. Councillor Perrott seems happy. Fine. So are we happy then to accept the suggestion that the minor points which were discussed at the chairman's briefing are processed, and the ones that the officers weren't happy about are just forgotten about? Are we happy about that? Yep.
Maybe just to give the committee some reassurance, it's things like it was 7 working days, and I said, should it not be 5? Those sorts of things. So those are the sorts of work done ones that just saying, let's move on.
Fine, so let's get that one out of the way. So this is the disciplinary policy and procedure, statutory and non-statutory, for the CMT, and we are asked to resolve that the current disciplinary policy and procedure, statutory, be removed as standalone policy, and that the new one takes its place, essentially. Okay, agreed? Agreed. Good. Okay. Sally, do you want to go on to the grievance one then? Sorry, that was my fault. I created confusion there.
Yes, please accept my apologies for jumping around. So
No.
So yes, the grievance policy, again, a couple of tiny administrative tweaks, happy with those. They're just mainly formatting, but there is this bit of feedback from Councillor MacDonald that I think would be really helpful just to talk through, and that's the sentence I referred to earlier, which is at the relating to complaints against councillors. So perhaps we could be good enough just to have a look at that it's the bottom paragraph of the first section, and then have a discussion about that, please.
Fine, so it's the last paragraph on page 23. And
Is it back with me again now?
back with you, yeah.
Okay,
If you
we've
could
got-
just
we've got-
clarify the point
We've
you
got
were
three
trying to
lights
make.
on, so just to help Ying, we might need to hit some lights. Thank you. Thank you, Chair. So just to orientate, do you have a page number for that, Ms Kipping? Right. So let me try and position it in an appropriate way. So the paragraph there is, and I wanted actually to have a discussion about that paragraph more generally, because I think it's worthy of discussion. It conceptually, as far as I understand it, if there's an issue with an employee, an officer, it goes down the HR route. If there's an issue with which can be, by the way, a grievance against a member, it would go down the. No, it could go down. I'm going to confuse myself. But in principle, it goes down. If it's an employee, it goes down. An officer, it goes down the employment kind of channel. If it's to do with a member, it goes down the monitoring officer channel. So the complexity is where there's a complaint against a councillor and the employer. And I noticed the words that we used here, that the head of paid service and or monitoring will decide whether and how the grievance process should apply, which is absolutely fine and perfect. I'm just wanting to understand how that would work in reality for the members that are only supposed to be in the monitoring officer channel getting pulled into the employment channel, which is not their channel. So that's kind of the context of that sentence, because under the we touched on this before, under the Human Rights Act 1998, the members do have some privileges with respect to the public interest and political. I can't remember the exact words, but the sort of the political environment. Obviously, there's a boundary there and everything else, but they do have some privileges, and it's just whether that was overriding it was my concern. Hence the statement. Maybe you'd like to comment, Ms Kipping, about how you meant that statement to mean.
Sorry, before you come in on that, can I just clarify the second line of this, where the sentence is where there is a complaint against the councillor and the employer, should the and be the word as?
No, it should be.
It shouldn't. Okay, that's fine. Good. Right. Do you want to comment?
Yes. Thank you, Chair. So this is an instance, this would refer to an instance, as I say, where there's been allegations against a particular councillor that, as you suggest, Councillor MacDonald should go down a monitoring officer route, but the CMT member also makes an allegation against the council as an employer, and that might be around, let's imagine, a failure to protect or failure to provide a safe place of work or something of that nature. These things, grievances made by CMT members tend to be quite complex, and they rarely are straightforward things to unpick. And so I think when I was writing this paragraph, I was really minded of that complexity and the knowledge that there are often many strands to a complaint by a CMT member, or indeed any senior officer, and that they would need to be sort of unpicked on a case-by-case basis, whether the primary complaint was against the employer or the primary complaint was against the councillor. I mean, in reality, it's the complaint against the employer that represents the bigger risk to the council in many ways, because it is that complaint that can lead to legal action. For example, let's say a discrimination claim or a claim for unfair dismissal or constructive dismissal. It's that can end up in an employment tribunal, and it's that process that would be really unpicked at that point. And we would need to show that we had followed a really fair process. Now, when you're an employee, that fair process tends to be the grievance process rather than a complaint process. But I absolutely agree with you that the rights of all participants need to be protected. And just with so many legal things, there are competing issues, as you point out here, and that's why I think it needs to be looked at on a case-by-case basis, and we need to take a lot of care about which route we go down, because whichever route we choose, we are open to criticism that we didn't follow a fair and correct process, and should we end up in an employment tribunal, we would have to account to that to the judge. And be very clear in our rationale and why we chose one process over another. So yes, I think when I was writing that paragraph, I was trying to express that these are complex matters and that it's very difficult to be very directive or prescriptive in a policy to say it will definitely go down this route or it will definitely go down that route, if that makes sense. But I absolutely accept that, you know, the rights of all parties, the privileges of all parties, as you have suggested, that careful consideration needs to be given to all of those when deciding the route. Of course, councillors are not employees and so are not compelled under any employment contract to behave in a particular way, although there is, of course, policies within our constitution, codes of conduct and so on, that protocols and whatnot, that sort of guide councillors in this instance. But I hope that gives a bit of context to that particular paragraph.
Can I,
Please.
Yeah, so thank you, Ms. Gibbon. So just to be clear, and that actually was going to be one of my questions or clarifications. So members are not employees of the council, and therefore the HR processes do not apply to them. Is that correct?
So there are policies that do apply to them, and there are policies that do not apply to them. And again, you have to look at each policy in its, you know, I'll give you a really good example. Health and safety at work applies to everybody within a workplace. So that would apply to councillors and officers alike. But there are some policies do apply to councillors and some do not. But you're absolutely correct in saying that councillors are not employees of the council, even though they perform a job of work for the council and, or more accurately, for the residents, and are paid an allowance. They are not employees.
Okay, thank you. So it's not intended to pull a member into that process because that process isn't relevant to them.
So a member potentially could be a witness, but they wouldn't, they can't have the outcome of that process. They could be asked for their views, but they could not be, there's no sort of outcome other than they could be asked to be a witness just because they happen to have seen something happen.
So the role rather than a receiver of an outcome.
Could you put your, sorry.
Councillor Hode.
Thank you. Thank you, Chair. I'm a bit rusty at this. So if I understand correctly, then what you're saying is for a councillor, their role would be more of a participant in the process rather than as a receiver of an outcome, a decision outcome.
So yes, exactly so. They are a participant or a witness. They can't be sanctioned by this process.
I'm being a bit
I mean,
pedantic.
I'd like just to, in an effort to move this on, I'd like to make a suggestion, if I might, which may or may not be acceptable to yourself and to the officers. It occurs to me that this paragraph, which is specifically about complaints against councillors, so this is where a member, and you'll correct me if I'm wrong, this is where a member of the CMT finds fault with something which an individual councillor has done. For I don't know, he might have been rude or something. So the way this is worded, and I think it's correct that it's worded, is fairly loosely, in the sense that where there is a complaint against a councillor and the employer, the head of paid service and or monitoring officer will decide whether and how the grievance process should apply. So that's pretty, free stuff. I'd like to suggest we then put a comma and insert the words taking into account the rights of the individual councillor. Would you be happy with that? Would you be happy with that?
Absolutely, Chair.
Fine. Does anybody else have anything to add? No? Good. Are we happy then as a committee to accept that change? Thank you. For some reason, I got it into my mind that there was going to be a whole list more of.
The others are just administrative ones, aren't they, Ms Kipping, which you'll deal with, as you said earlier, yeah, on this one.
Yes, so it's actually so there are some other bits of feedback, but they're grammatical or just adding a little bit of detail and whatnot. So again, very happy to go through it, but otherwise happy to accept it.
Councillor Perrott.
Yeah, I have a question. This may seem a little bit out of context, but would that then be would then the council take into consideration like precedents, things that have happened before, and base it on that? I mean, I don't know how relevant using precedents is in this case. Thank you.
Thank you, Councillor Councillor Perrott. I was saying precedent and Perrott at the same time. I do apologise. That's an excellent question. We do have regard for precedent in that we do think about things that have gone before and whether they should inform any particular present case. What we have found is that these cases are fortunately extremely rare, and when they come up, they tend to be, as I said before, very, very complex. And so what we do find is actually it's more helpful to judge each case on its merits. But what we wouldn't do is make a decision that was entirely contrary to a decision we'd made before. So if you like, precedent is of interest and we do consider it, but we do look at each case on its merits.
Okay, I trust you're happy with that?
Thank you. Thank you.
Right, so I think we can go to the resolution, which is exactly the same as the previous one, that the current grievance policy and procedure, statutory and non-statutory CMT, be removed as a standalone policy, and that the grievance policy and procedure, statutory and non, as set out at Annex A to the agenda report, be adopted as an annex to the main grievance policy. Are we agreed on that? Thank you. Right, that then brings us to, I think, the probation policy. Are you going to take that again? Very good. Right, please do.
Thank you, Chair. Firstly, I need to apologise to the committee. We got our annex numbering a little bit confused. So if you were searching for Annex 1 but could only find Annex 2...
As I was.
As the Chair was, please do accept my apologies for that. The Chair was absolutely correct, as he always is, and we had misnumbered the annexes. The probation policy is quite an important policy to us as a council because it does enable us to dismiss an underperforming new recruit. And there is a process that accompanies that within the policy. We are treating this, although we had a probation policy, it was not fit for purpose, and therefore we have brought this to Employment Committee effectively as a brand new policy because we have changed it so considerably. The reason we changed it was that we had a couple of cases over the last year or so where we very much struggled with implementing the old probation policy. So wrote this one to right those wrongs, if you like. We'll very much welcome the scrutiny and questions of the committee on this one. Thank you.
I believe there were a couple of points that I raised on this, but I think we agreed that I was not correct, and so we can forget about that. Has anybody else got any other points to raise on what is potentially quite a confusing situation? And I think the policy as written has dealt with that that complexity very well. Any other comments? Councillor Thorne.
Thank you, Chair. Just a quick one, just with regards to the record, keeping the record sides of the policy. Do we know what the time frame is of which we have to keep the records of the probation period are, as in the how many years as such? And kind of alongside that, I know obviously it says that the managers must submit all meeting notes and etc. to the HR team. Is there anything to say that the managers themselves should or shouldn't keep copies of those meetings for themselves as well as a duplicate, or should it only be held by HR? Thank you.
That's a good point, Sally.
Very good questions. So we do have different retention periods for different things on any employee. A probationer obviously has been an employee for a while, so we do have different retention periods documented for the records of the meetings, but for the general employment, because of course they would have had pension and so on during their time. So we do keep the employee records in accordance with our privacy and retention policies. I would just need to check the policies to give you absolutely accurate information about how long that is, but from recollection we generally keep things like disciplinary grievances and information about dismissals for, I believe it's 3 years, but I can check that and get back to you. In terms of the second question around whether the manager should or shouldn't keep their own set of notes, we do encourage all records to be held centrally by HR so that there is just one version of the truth, if that makes sense. Having said that, that isn't especially policed, as it were. So although when HR is involved in meetings, they take the notes, they keep the records. And of course, that would happen towards the end of any unsuccessful probationary period. As I say, we wouldn't give advice to managers to keep separate notes, but we don't police that point. So that is something that, you know, that might be something that you'd want us to look into in the future.
Okay, happy with that? Yep, good. Okay, unless there are any other points, we'll come to the recommendation, which is that we're advised to resolve that the revised probation policy and procedures set out Annex A of the agenda report be adopted. Are we so agreed? Thank you. The next item on the agenda is the member and officer protocol. Is it a protocol? Yes, it is. There's been some discussion about this at the member briefing, at the chair's briefing in particular, as a result of which we would like to propose, following discussion with the monitoring officer, the Chief Executive and your good self, Sally, we'd like to propose that this item be deferred for further consideration. Is that so agreed? Okay, yes, Councillor MacDonald?
Could I suggest that your good self as chair join any discussion that we might have on this, on reviewing these things? Because I think we all acknowledge this is a bit of a funny one because it's in the phrase, isn't it? Officer and member, two things combined, so it sort of sits across two stools. But I could see some real value in you joining that discussion, so we have some rational thinking there.
I'm quite happy to go along with that. If that's felt to be a good idea. You okay with that?
The policy is actually owned by Natalie Boateng, our monitoring officer, but I'm sure she would also be in agreement that that was a good way forward.
Okay, well, subject to her agreement then, let's do that.
Testing your patience quite a bit, I can see. But just to thinking aloud, I haven't had a chance to look, to be honest. Is there an implication on full council next week? Because I think it's on the agenda for full council. I just wondered how we deal with that.
Are you in a position to comment on that, Rachel?
Thank you, Chair. Yes, I think it would need to be deferred from the full council because if it's not being recommended by this committee, I think you need at this point to defer it from that meeting and then just refer it to a later meeting, basically.
Okay, so we'll just advise the full council it's been deferred and we'll come back. Okay. Councillor Hode.
And is there any implication we should be aware of deferring it to a subsequent full council rather than the upcoming one?
Comment on that?
I don't believe so, no.
Fine. Okay. Good. Are we so agreed that that be deferred then? Right. Good. Thank you. Okay, that takes us to the minutes of the appointment subcommittee, which we found a bit confusing at first because we assumed it was the one which took place 2 weeks ago. Actually, it's the one which took place. You'll remind me when it took place, I hope.
It was a while ago. It was
Yeah.
Miss Radford, and so it would have been, I'm going to say, April. It was 25th of March, 2025.
Close. Fine. So the this was the meeting which resulted in the appointment of the new Section 151 officer, who I think it's true to say has settled in extremely well. So if you're happy for me to sign those minutes, I will do so. Okay, thank you. Okay, so that then leads us, I think, to the last item on the agenda, which is the work programme. Does anybody want to make any comments on that, which is attached to Annex A on page 60 of the pack? Councillor MacDonald?
Sorry, Chair. I keep looking at all of these things and thinking, do we have to do them? I know we don't know what our future is. We might know by some of these dates what our future is, an indication. I see they've been up on their feet today in the House of Commons talking about some stuff related to this, and I think the Minister was kind enough to send me a letter, 4 pages. So I was just looking through this list, and I think it's a similar discussion to the one we had before at the last committee meeting, to sort of say, is there any of this work we could defer? Now, some of them, I think I remember being told last time, we have to do because they're legal requirements or we think are very important to do. But I was just, again, challenging myself and challenging the committee to think, are there any of these that could be deferred in the interest of not doing work that has a short time space? I don't know whether the officers want to comment as to whether they see any opportunities there that could be considered.
Yes. one of the things that perhaps we could do is to, subject to the officer's comments, is agree this work programme subject to any changes which might come forward as a result of local government reorganisation. There are things here, for example, the speak up policy, just to take one at random, which is due to be discussed in January 2026. If it turns out that in November of this year, a full and final proposition is put forward in respect of the new arrangements, there seems to be limited point in talking about that at that point. But would you like to comment on that?
The Speak Up policy is effectively our whistleblowing policy, and my understanding is that it's a requirement for us to bring that on an annual basis, along with there's a few policies that we must bring annually, so the pensions discretion policy, the pay policy, and so on. There is some room for movement here. So I'm particularly thinking that a couple of the recruitment policy, for instance, we could make that update and I think get it signed off by head of paid service rather than bring it back to committee, because it is just a minor update, and I think our constitution has now changed to allow us to do that. So there are things that I think we can possibly refine. We might want to put the officer member protocol back on for September. I'm thinking. I think the exceptional payments has to come because we're looking at what we might do with secondments and just clarifying that. And because that affects our base budget and it's about payments, I think that our constitution says it must come to the employment committee, but I will check that. I am sure, though, that as you are correct, Chair, in that as we go, obviously we'll review things that we're bringing to ask ourselves, well, whether we really genuinely have to. And certainly from April 2026, I'm imagining the work programme of this committee will be really just annual and statutory things that we have to bring, because at that point, of course, we won't really be making any material changes.
Okay. Yeah, please.
Really appreciate that, and I think that's the right approach. You just challenge yourself to continue to look at it, but just looking at it from a different angle for a second, Ms. Kipping, in the interest of making this as beneficial as possible for the staff. I know in discussions with the chief executive, there is some consideration being given to exactly what you said, secondments related to LGR activities. Potentially also, as we go down that pipeline, we might find it increasingly difficult to share, to recruit resources, and we might look to a more shared model with other boroughs. And I think there is some consideration, probably through your own HR work group with your peer group, as to having a standardised mechanism for doing that. So that we don't keep, getting into haggling with each individual employee. We just have a standard approach to it, and hopefully they make it work. We make it work for them, and we make it work for the council in taking on those additional responsibilities. The councils probably in that case. Is that what is there one of these policies that relate to that, or do we need to put a line item in to give ourselves the space to approve that? Because I guess even if it's agreed, for argument's sake, between yourself and your peers and the chief executive group are over the moon about it, and certainly the leaders are not going to push back on it because we think it's the right thing to do in terms of managing the risk to the council of having high quality people doing dedicated work for our residents. But it still might technically need approving because it would be a material change, or would it?
Yes, you're absolutely right. I think that we're seeing it potentially as part of our exceptional payments policy, which covers acting up at the moment. So we would put a secondment section in there. My concern is that we might be aiming too soon in September, and that I feel we already have had discussions about what a secondment policy might look like. I think we all feel that just adopting the LGA model policy would probably be the best approach. But it will be tricky to get all of that agreed by September, I think. So, it's already on there in September. It might need to be deferred.
Could I just suggest that we agree that the work program, or we agree the work programme, but make it clear that it's subject to LGR and any ongoing developments arising therefrom. I'm sure you can put that into a better form of words than I just said, but you get the point, I think. So are we agreed on that, or does anybody have any further comments? No? Good. Okay, that is agreed then. And that, I believe, concludes the meeting. So I wish you a very good evening. Go and sit in the garden with a beer or something. Good night.
Thank you. Good night.
Good night.